My dear and respected colleagues at the bar, distinguished persons, learned friends, ladies and gentlemen, today I am sharing my views on the very important subject, that is judicial restraint and constitutional responsibility in the wake of the controversy erupted over the recent remarks made by the Honorable Chief Justice of India. My friends, here I am not to criticize any individual occupying a constitutional office, but to express a principled concern regarding the larger institutional culture that is gradually emerging within our democratic framework. My friends, recently certain remarks reportedly made by Honorable Chief Justice of India during the court proceedings have generated widespread discussion within the legal fraternity and the civil society. My friends, as Laula reported, while hearing the case, CJI shared his views about some of the lawyers in Delhi. He said, I am waiting for some matter. I want CBI to verify the LLB degrees of most of the Delhi people in this Hazari, so and so. And the kind of Facebook thing and Facebook and things they are putting, do they think we are not watching? BCI will not do. BCI means Bar Council of India will not do anything. Thousands of them are fraudulent people who are wearing black robes. I have serious doubts on the genuineness of their law degrees. Probably CBI will have to do something. Bar Council of India will never do because they are hands in glove. They will have to do something. And BCI will never do because they are hands in glove. They are absolutely in collusion. That's what the Chief Justice of India said. Then there are youngsters like Cocroches who don't get employment and don't have any place in profession, legal profession. Some of them become media. Some of them become social media. Some of them become RTA activists. Some of them become other activists. And they start attacking everyone. And you people file contempt petitions. My friends, with utmost respect to the office of the Honorable Chief Justice of India, many among us feel that the language and sweep of those observations require careful constitutional reflection. Of course, the subsequent clarification by Honorable Chief Justice of India in the face of mounting criticism may assuage the hurt feelings of our legal fraternity because of the affinity between the bench and bar. But the educated youth, unemployed, and social activists, civil society, and journalists are yet to recover from the shock and dismay, and its impact will not go that easily with a cover-up clarification. My friends, as a practicing advocate who has witnessed the court functioning for more than 4 decades, I have seen a very different judicial culture in earlier decades. Judges of higher courts maintained extraordinary restraint both inside and outside the courtrooms. They seldom made unnecessary oral observations. They avoided comments beyond the scope of the matter being heard. They believed that the judges must speak primarily through judgments and not through rhetoric from the bench. That restraint was not silence born out of weakness, but it was institutional discipline. It protected the dignity of the judiciary and strengthened the public confidence in judicial impartiality. Unfortunately, my friends, in recent years, we increasingly witness the oral remarks during the hearings that sometimes create impressions regarding the likely outcome of the cases even before judgments are delivered. At times, comments appear unrelated to the legal controversy involved and occasionally carry political or ideological overtones, whether intended or not. Such developments create apprehensions regarding neutrality and institutional balance. The issue becomes more sensitive in the background of public debates the surrounding post-retirement appointments accepted by some judges after delivering important judgment while in office just before their retirement. In such a climate, every public statement from the constitutional courts naturally attracts deeper scrutiny. Therefore, when sweeping remarks are made against thousands of advocates, when doubts are cast generally upon the genuineness of law degrees, when the Bar Council of India is described as being in collusion, or when educated unemployed youth described in insulting terms such as cockroaches and parasites, concern is both natural and legitimate. If any advocate possesses fake credentials, let action be taken under law. Nobody supports illegality, but there are statutory mechanisms available. Concerned state bar councils and bar associations can verify the credentials of an advocate when he comes for enrollment. Due process exists, but sweeping remarks against an entire profession can create an atmosphere of intimidation rather than reform, more particularly when soliciting the intervention of the CBI. The bar is not an enemy of the judiciary, my friends. The bar and bench are two sides of the same coin of justice. Advocates are not merely professionals earning livelihoods. Historically, lawyers have defended civil liberties, constitutional governance, and democratic rights. The duty of an advocate is not only towards his client, but also towards the cause of justice. Likewise, educated, employed youth are not cockroaches, my friends. They are citizens of this great republic. They possess constitutional rights under Article 19. They have every right to question the institutions, participate in the public discourse, and engage in journalism, RTI, and RTI activism or democratic movements. In a constitutional democracy, questioning authority cannot be equated with hostility towards the nation or the institution of judiciary. At the same time, my friends, criticism of the judiciary must also remain responsible and dignified. We must protect the independence of the judiciary, because without an independent judiciary, there can be no constitutional democracy. But the independence of the judiciary and judicial accountability are not contradictory concepts, my friends. Judicial independence is strengthened, not weakened, by restraint, humility, constitutional balance, and institutional sobriety. The greatness of the constitutional courts lies not in harsh words, but in calm reasoning. Judges earn moral authority when their judgments inspire confidence across ideological and political lines. The majesty of the judiciary is preserved when courts rise above political language and remain firmly anchored in constitutional values. So, my friends, today, more than ever before, India requires institutions that inspire confidence, not fear, dialogue, not intimidation, constitutional morality, not rhetorical aggression. Let all institutions, the executive, the legislature, media, bar, and judiciary, function within the constitutional boundaries with mutual respect. That alone will preserve the spirit of our constitution and strengthen the faith of future generations in democracy and rule of law. My friends, I hope that you will agree with my views. Thank you.